Welcome to another Legal Talk with Hahn and Hahn attorneys. Today we chat to Nirvana Pillay from the firm, and we talk about this very interesting topic. It almost sounds like the plot for a movie. I think they made a few movies where a family member passed away, he or she didn't have a will, and now the family members are left fighting over money and possessions. This could get really ugly. So what happens now when there's no will? Nirvana, hello and welcome.
Hi, Ian. Thank you for having me again.
It's always nice to have you on the show. First of all, Nirvana, can you please explain to us the different types of deceased estates?
So when individuals die, they are considered to have either died in terms of testate or intestate succession. So intestate succession being where the deceased leaves no valid will, and then the estate devolves in terms of the Interstate Succession Act 81 of 1987, and testate succession where the deceased has left a valid will and the estate therefore devolves in terms of that will. So the listener's question deals with the interstate succession where the deceased has not left a valid will.
Okay, and how will the executor of the estate be appointed where no will has actually been left?
So generally, the heirs of the estate will nominate the executor and make submissions to the master's office upon reporting the estate. However, there may be instances where the heirs do not agree on the person or persons to be appointed or fail to make the necessary nominations. So then, in terms of Section 18 of the Administration of Estates Act, the Master of the High Court, where a person has died without a will, may appoint and grant letters of executorship to such a person or persons whom he deems fit and proper to be the executor or executors of the estate of the deceased. Then in terms of Section 19 of the Administration of Estates Act, should more than one person have been nominated for recommendation to the master will give preference to the surviving spouse or his or her nominee. If there's no surviving spouse, then to the heir or his or her nominee. If no heir is nominated or no heir has nominated any other person, then a creditor or his or her nominee. And then you also have the tutor or curator of any heir or creditor nominated who is a minor or person under curatorship in the place of such heir or creditor. And this is provided that the master may join any other person as co-executor as well. Or if there's any good reason, may pass on all those individuals and just elect an independent person to be appointed as executor.
Okay, how do we determine who will inherit in terms of interstate succession?
So the distribution of the estate is governed by the Interstate Succession Act, while the administration of the estate is governed by the Administration of Estates Act. In terms of the Interstate Succession Act, the beneficiaries in order of preference would be the spouse of the deceased, the descendants of the deceased, that's your children, the parents of the deceased, only if the deceased died without leaving a surviving spouse or children, the siblings of the deceased, only if one or both of the parents are predeceased. The Interstate Succession Act should also be read in such a way that it can accommodate cases where the deceased was a husband in a polygamous customary union, so where there's more than one spouse.
Okay, and I'm wondering then, how do we determine the share that each beneficiary receives in terms of the estate, Nirvana?
All right, so firstly, if the deceased was married in community of property, the surviving spouse must receive his or her half share of the joint estate. And then if the deceased was married out of community of property with the accrual, the surviving spouse will have a claim against the deceased estate for an accrual share. Only once the debts have been paid off and the surviving spouse has received his or her share in terms of the marriage and community of property, or his or her share in terms of the accrual, can the deceased estate be distributed. All right, so when a spouse dies and is survived by a surviving spouse and children, a child share must be calculated. To calculate a child share, you divide the value of the estate by the number of children of the deceased plus one, being the surviving spouse, or in a polygamous customary union, the number of spouses. A spouse must receive either 250,000 Rand, which is the amount determined by the minister from time to time in the government gazette, or child share, whichever is the greater amount.
That's interesting. Now, Nirvana, can you provide the listeners with a few examples of how the distribution would be made in different scenarios?
All right. So if a deceased is survived by a spouse or spouses, but no children, the spouse or spouses will be the sole intestate heirs. If a deceased is survived by the descendant, which are the children, but not by a spouse, then the descendants will inherit the intestate estate. Where deceased is survived by both the spouse or spouses and children, then the spouse or spouses inherit the greater of 250,000 Rand or a child share. And the children will inherit the balance of the estate. So child share, like I said before, is when you divide the intestate estate by the number of surviving children of the deceased and the number of surviving spouses. So, for example, where you have a polygamous marriage and you have an intestate estate of 2 million Rand, the deceased is survived by 2 spouses and 3 children. A child share amounts to 400,000 Rand because the 2 million is then divided by 5, the 3 children and the 2 spouses. And then an example of child share in the event of a monogamous marriage would be the same calculation. You would just divide the 2 million by 4. So 3 children and 1 spouse. So then each party would then inherit 500,000 Rand. And then where a deceased does not leave a spouse or descendant or parents or descendants of his parents, then the nearest blood relation will inherit the entire intestate estate. And if the deceased is not survived by any relative, this is the instance where the proceeds of the estate will devolve onto the state itself.
Can children born out of wedlock and adopted children also inherit in terms of the interstate succession?
So the answer to this question is yes in both instances. A child born out of wedlock can inherit from both blood relations, the same as a child who's born in wedlock. And an adopted child will be deemed to be a descendant of his adopted parent or parents. Therefore, that child will be able to inherit.
Okay, and lastly, Nirvana, and I think we all know the answer to this, but do you believe that leaving a will is important?
Yes, I do believe that leaving a will is important because you're able to ensure that your estate is divided amongst those beneficiaries of your choosing and in the amounts and proportions you have carefully considered, that they alleviates the infighting amongst family members. And you will also ensure that the estate administration process is accelerated if you nominate an executor in your will, which protects vulnerable family members without critical income from a delayed estate administration process. So you can also name the guardians of your children in your will and include specific provisions for a beneficiary who may have special needs. So yes, I do believe that creating a will is very, very important.
And then listeners can contact Hahn & Hahn, the law firm, to also assist them with these matters, drawing up a will and so forth.
Yes, that's correct.
Nirvana, thank you so much. That was very interesting. Bit of a sensitive topic today. Well, thank you so much for your input. Until next time.
Thank you so much. Thank you for your time.
Are you or your business in trouble and struggling to find a solution? Call Hahn & Hahn Attorneys as we assist clients in finding solutions. We specialize in consumer and food law, commercial and construction law, forensic investigations and administrative law. Visit hahnlaw.co.za. That's HAHN. We assist clients nationwide. Hahn & Hahn Attorneys, because we care. Don't miss Legal Talk with Hahn & Hahn Attorneys, Wednesday mornings at 10 on eRadio.